बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलल्लाह वसल्लम अलैका या हबीबल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ आप सब लोग खैरियत से होंगे। अल्लाह ताला आपको सेहत के साथ लंबी ज़िंदगी अता फरमाए। और मेरी नए आने वाले दोस्तों से गुजारिश है कि वो मेरे चैनल को सब्सक्राइब कर लें और घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। प्यारे व्यूवर्स, आज हम पढ़ेंगे सेक्शन 141 Procedure on failure to appoint jury or omission to return verdict. If the applicant by neglect or otherwise prevents the appointment of the jury, or if from any cause the jury appointed do not return their verdict within the time fixed, or within such further time as the magistrate may in his discretion allow, the magistrate may pass such order as the thinks fit, and such order shall be executed in the manner provided by section 140. Section 142 Injunctions pending inquiry. Number 1. If a magistrate making an order under section 133 considers that immediate measures should be taken to prevent imminent danger or injury of a serious kind to the publics, he may, whether a jury is to be or has been appointed or not, issue such an injunction to the person against whom the order was made, as is required to obviate or present such danger or injury pending the determination of the matter. Number 2. In default of such person forthwith obeying such injunctions, magistrate may himself use or cause to be used such means as he thinks fit to obviate such danger or to prevent such injury. Number 3. No suit shall lie in respect of anything done in good faith by magistrate under this section. Section 143. Magistrate may prohibit repetition or continuance of public nuisance. A magistrate of the first class may order any person not to repeat or continue a public nuisance as defined in the Pakistan Penal Code or any special or local law. Producer in office. Number 5. Where such an application is received, the Zilla Nazim shall afford to the applicant an early opportunity of appearing before him, either in person or by pleader, and showing cause against the order. And if the Zilla Nazim reject the application wholly or in part, he shall regard in writing his reasons for so doing. Number 6. No order under this section shall remain in force for more than two consecutive days and not more than 7 days in a month from the making thereof, unless in cases of danger to human life, health, or society, or a likelihood of a not of a root or an affray. The provincial government by notification in the official gazette otherwise directs. Number 7th, in the application of subsections 1 to 6 to the districts where the local government elections have not been held, or the Zilla Nazim has not assumed charge of police, but any reference in those provisions to the Zilla Nazim shall be read as a reference to the district coordination officer in relation to such districts, provided that his subsection shall cease to have effect and shall be deemed to have been repealed at the time when local government are installed in the district government as aforesaid. Commentary, scope and extent. Section 144 CRPC is a transitory provision meant to cater for temporary situation or to facilitate the stop-gap arrangement till alternate measures could be taken to safeguard the interest of the individuals and to preserve public peace and tranquility. PLD 1996, LAH 133, magistrate not empowered to decide dispute of civil nature. 1991 PCRLJ 218. Violation does not entitle police to put nickel in nose of violators. NLR 1991 UC 29. Attachment of property in initial essential requirement PLD 1991 AJ and K 60. Action taken in consultation with government not illegal PLD 1956 FC 190. Religious practices purported to be performed opposed to religious susceptibilities can be prevented under section 144 CRPC PLD 1956 FC 190. It is general right of the public to take out prosecution on public streets. Law does not envisage a total prohibition. PLD 1983. SC 140, 174, 172. Person visiting district from outside covered by subclass 3 of section 144 PLD 1972 LAH 836 curfew ADM and SDM not competent to opposed PLD 1969 DACCA 961 proceedings under section 107 151 dropped section 144 cannot be put into operation 1971 PCRLJ 228 order under section 144 under 4 5 should not be passed unless absolutely necessary, i.e., to meet emergent danger when sufficient and adequate remedy is not available. PLD 1966 LH 675 CPLD 1970 PESH 19 satisfaction of district magistrate subjective PLD 1972 LH 836 order under section 144 contemplates preventive and punitive action PLD 1968 LH 1353 serve of notice necessary if practicable can be notified by proclamation 1986 68 SCMR 290. Order should be addressed to individual and served in the prescribed manner. PLD 1992 KLR CR 344 magistrate cannot recover share of Batai 1991 PCRLJ 218 ignorance of order a good defense 1991 PCRLJ note 141 page 104 order passed mechanically respondent not heard before passing the order without lawful authority to 2000 PCRLJ 1554 subdivisional magistrate take cognizance of offense and police report and not an complaint by public servant concerned as required under section 195A. Mandatory provision of law violated 2002 MLD 1039 number 2 case registered by ASI. ASI being registered, ASI being not authority in terms of section 195 1A not authorized to register case FIR label to be cancelled 2000 2004 YLR 380. Number 3, video games. Video games, billiard and carom. These games, no debate, kill time, but keep away youngster generation from crimes order under section 144 CRPC can be justified only in case of absolute necessity. PLJ 1993. LAH 1. Action taken under valid law 1993 SCMR. District magistrate has no powers to extend order identifiably till further order 1993 SCMR 1718. Number 4, kite flying. Zilla Nazim and government cannot direct or indirectly in exercise of powers under this section interfere, curb, forfeit, suspend or take away fundamental right given under Article 18 of the Constitution. These rights, in view of Article 4 and 8 of the Constitution, are inviolable. Notification in branch of constitutional rights. Power conferred on Zilla Nazim and government to meet grave situation in vogue since long permanent solution would have been found to meet the problem by making a law rather than allowing the Zilla Nazim and government to exercise the powers under this section. PLD 2004 and LAH 201. Number 5, election. Gathering of people near polling booth or taking voters to elections placed cannot be construed as a violation of section 144 1999 PCRLJ 1221. Section number 6, section 144 as amended. Power under this section can be exercised only by a Zilla Nazim secretary, Home Department, or any other authority has no jurisdiction to exercise such powers. 2003 YLR 2097. Number 7th, power of magistrates. Prohibitory order can be passed by district magistrate only for a period of 2 months, and if restriction is necessary to operate for a further period, then only provincial government can pass order under section 144(6). District magistrate not competent to pass order after expiry of 2 months. 2003 YLR 893. Next chapter inshallah, disputes as to movable property inshallah kal पढ़ेंगे। तब तक के लिए मुझे इजाज़त दें। अल्लाह आपका हामी और नासिर हो। आखिर में मैं अपने तमाम दोस्तों से गुजारिश करूँगा कि मेरे इस वीडियो को शुरू से लेकर आखिर तक देखें, ताकि आप लोग कानून के बारे में आगाही हासिल कर सकें। और मेरी आप तमाम दो लोगों से रिक्वेस्ट है कि घंटी और लाइक के बटन को ज़रूर ऑन कर दिया करें, ताकि हर नई वीडियो आने वाली आप तक पहुंच सके। तब तक के लिए अल्लाह हाफ़िज़। अल्लाह आपका हामी और नासिर हो।